Hello, everybody. Hello, Andrei. Hello, Raluca.
Hi,
Hello.
hi, Ioana.
How
And
are
hello,
you
everybody.
feeling now that the panel you are expecting the longest has come? We are going to discuss about MICA regulations and lots of legal and tax stuff, which might seem maybe boring at a first glance, but I'm sure that you all have interacted with this. I'm sure that you want your businesses to stay safe, for your projects to be, safeguarded from this perspective. So we are here to explain lots of stuff from this perspective. We try to identify some hot topics in the legal and tax area. We are going to speak a bit about how businesses are being regulated, because in Europe, we all know there is no legal framework applicable at the level of the European Union yet. And while, there are licenses, there is a big discussion as to what to do in advance of MICA and how life will be after MICA. Then a second topic that we will want to address is about tokenization and utility tokens versus security tokens and financial instruments. And finally, the third one is going to be about stablecoins, what we consider to be a very interesting use case. And we have here what we think are the best persons, the most suited to help us clarify this. Andrei is a legal expert, Deloitte Central Europe partner. Raluca is tax expert, Deloitte as well. And we are going to start with the first topic. So we all hear a lot about MICA. There are various discussions. Maybe I will start with you, Andrei, and what do you think maybe you can share, first of all, an angle, something that we have not heard in the space about MICA. No pressure, but people are here for this panel, so.
Great. Thanks a lot, Ioana, for the introduction. I don't know how many of you know how big is MICA. For years, people in the crypto space said, with a bit of hope, institutions are coming. Yeah, that's like the moment when we will be in triumph. Yeah. Well, institutions have come big times, and institutionalization, if I may use this, improperly use this word, also came. So MICA has a bit over 160 pages. And ESMA, which is the European Securities Markets Authority, which is actually enforcing MICA, and which is the European securities regulator of all securities regulators in Europe, has started to pass secondary legislation, which is currently in draft form. If you look at the text of MICA and the text of the secondary legislation that we have as of now, we're a bit over 600 pages. My estimation is that by the time ESMA completes to issue all the RTS, all the secondary legislation, we'll probably have like 1,000 pages of regulations governing crypto asset services. And I'm talking, this would be direct regulations. And then you have indirectly applicable regulations, whether it's tax, AML, and so on. So my first comment here is Europe went on in style big time when it came to regulating crypto assets, which is going to be a big challenge and a big burden for a lot of the DeFi, not the DeFi, a lot of the crypto native players, because most of the players are not used with that level of regulation. On the other hand, is also an opportunity, okay? Why? Because the way that crypto space is being regulated in MICA is actually resembling a lot to how capital markets and financial institutions are regulated, which implicitly, one, acknowledges that we have a financial space, and secondly, that instead of being banned, and instead of going throughout endless litigations and disputes about it, we come and say we take it seriously at European level, we regulate it in a similar manner, okay, and we move ahead with it. So that's one aspect that I think is very, very important to point out.
Raluca, now MICA, as we know it, it's rather about the legal framework, so it's not in itself a tax regulation. But I would like to ask you, is there any impact on the tax framework, maybe where we are from this perspective?
Well, actually, MICA is highly relevant for the tech space as well, because actually, I will need to put a bit of context around this. I don't know how many of you know, but hopefully this has hit the news for a while now. The idea is that at a broader level, meaning at OECD level, a standard has been developed around the exchange of information on crypto assets. This standard is further, let's say, brought risen into the European legislation, meaning that a current framework for administrative cooperation between tax offices within the European Union is being amended for the 8th time. And I'm going to mention this law going forward as DAC 8. And this has been specifically drafted to, let's say, regulate the reporting on crypto assets transfers. What does it mean? It means that, and by the way, the European part is very recent. It has been adopted unanimously this Tuesday. It will have 20 days up until publication in the official journal, and then there will be time to have it implemented in the national legislations, and starting 2026, we will have the reporting in place, yeah? Which means that this is where the DAC 8 connects with MICA, because European legislation needs to be coherent, and it actually reflects in big part all the definitions, and it uses the same language and the same approach as it is done in MICA. And crypto asset service providers will have to report on an annual basis in aggregate terms per individual client, yeah, using their tax identification number, the transactions made. This is with the aim to make this visible to the tax offices, such that at each country they will be able to enforce their national law around taxing those gain, proceeds, and so on and so forth. What is also, let's say, important to mention here is that there is also a bit of a, let's say, divergence against MICA, in the sense that whilst MICA does not deal with staking and lending, the DAC 8 requires that staking and lending will be also reported, yeah? So currently there is a lot of debate around how to properly define staking, such as to allow the crypto asset service providers to properly distinguish between the various transactions that they need to report and identify as such. If I'm not mistaken, I think that the only other thing which is important is that it does not deal with peer-to-peer transactions. So those transactions will not need to be reported, but let's say the flows from the crypto asset service provider to self-hosted wallets will need to be reported. The only thing that remains is actually clarity at national level when it comes to how taxation actually works in this space, because each country has its own, let's say, pace in regulating this. Some are more regulated, like Germany, others are way back.
Thank you so much, both of you. Maybe another angle from where to approach MICA, but not only that, is the one of tokens. So we have in the audience businesses, projects, they have issued tokens in the past. Europe seems like maybe a safe haven from perspective of not having the issue and the risks of having tokens qualified as securities. So we do not read daily in the news press about the Security Exchange Commission, sanctioning or affecting businesses from this perspective. I think the idea would be to try to see whether this is something that is going to change after MICA. Is it really Europe a safe haven right now? I mean, the only moment when it's being relevant whether a token may be qualified as security or not, it's when you want to list it on an exchange in the US, most likely, and you have to produce a legal opinion saying that, you know, the token is an utility token. But do projects need to do something from this perspective? Are they really, you know, that safe as we think they are? Will it change after MICA?
Yeah, it will change, it will not change, yeah? Because in reality, even today, if you issue a token and address it to the public, you should talk to your lawyer and make sure you know for sure that that token is not a security, and more specifically, not a tradable security. Because, you know, some people tend to believe that because something is a token, it's on blockchain, it necessarily means it does not fall under any law. Well, it depends. What MICA says is that, and it says this specifically, that is not dealing with tokens which are financial instruments, okay? So if they are financial instruments, they are not within the scope of MICA. So from that perspective, the fact that MICA comes into place does not change the thing, because it does not aim to regulate security tokens, okay? Where it is an impact is in the fact that when you will be issuing a white paper, you'd have to make sure that you had the legal opinion confirming that that token is not a security. And the issue of a white paper becomes mandatory. And as a tip of advice, ESMA already recommended to the market players to start considering to prepare white papers in line with MICA, even, you know, so MICA is not yet applicable. In other words, you know, Christmas is coming with MICA, because, by the way, MICA is literally coming on Christmas next year, yeah? That's when it's 24 December next year, yeah? MICA becomes effective, okay? But Christmas, you know, is not going to bring only gifts, yeah? So you have to make sure. And you asked me whether, do we have a risk in Europe to see stuff like what's happening in US? First of all, in US, there are two types of things happening. One, the famous or infamous, whatever you want to call them, litigations between SEC and various market players. SEC claiming that certain tokens are securities, and therefore, you know, you should observe the securities laws. But there are also enforcement actions by the commodities regulator, who is also saying, oh, no, we don't believe they are securities, we believe they are commodities. Guess what? There's a law also for trading commodities, yeah? So my advice to everybody is make your assessment right. Beware that simply putting a disclaimer in a white paper, I've seen a lot of those saying this is not a security. Well, that's a valuable disclaimer if it is not a security, yeah? So I would stop here for now.
Speaking of tokens, Raluca, might not be relevant. I don't know how many of you in the room have tokens or crypto in your wallets, but still I will ask the question. So if we are individuals holding tokens, being from staking, trading, minting, what would be, I don't know, top 5 things that we need to know in order to be tax optim, tax secure, relevant from this perspective?
Well, it's a tough question because you know, this space is not properly regulated in the tax law. The Romanian, at least, tax law is quite general, and there have been, you know, a series of myths with, as time goes by, are being debunked. Some by the practice, some by the very tax offices. So. So currently there is no distinction between, let's say, crypto asset trading along any other type of token. But that doesn't mean that you know, any sort of income being generated out of these assets is not taxable. So on one hand, we have what we would call, you know, crypto asset investment, yeah, I mean, mere trading, and these are taxable operations and are to be reported individually and taxed with 10% between the sell price minus acquisition price, with some limited non-taxable amounts, but they are immaterial. However, you know, this becomes actually taxable when people would typically take out the money from an exchange to fiat, because that is when a real tangible gain occurs. But here comes the other myth, in the sense that this is not actually the only time when a taxable operation occurs, and I think individuals need to be aware that they may, obtain certain assets via different means, like for employment, for a service provision that they would do on their own, for actually creating some digitalized art or stuff like that. And each of these cases represent, a different type of source of income and need to be analyzed separately and have their own tax regime, yeah? So it's not a matter of fact that I did not take it into fiat. I actually might have a taxable moment if I deliver a service, yeah? The moment I receive that crypto asset, yeah?
If I may,
Please.
just coming back a bit, complete something about, add something about the qualification as securities, yeah? There's not necessarily like, the worst thing that could happen, provided that you understand it upfront and you deal with it accordingly, yeah? And there's a piece of legislation that, to my surprise, was less debated in the crypto space. It's called the DLT pilot regime. It's a European regulation that creates a regulatory sandbox, allowing for the creation of market infrastructure. I'm talking financial markets infrastructure, capital markets infrastructure, based on distributed ledger technology, blockchain being an example of DLT, okay? And in my view, that is the basis for one of the best use cases that blockchain can have, and which have already been implemented in practice in US. I mean, you have heard the news, I think it was last week, JP Morgan came out and said they tokenized BlackRock money market funds units, okay? The money market fund is a huge market globally, okay? So tokenizing financial instruments on the blockchain is really a big thing. The advantages being 24 out on 24 trading, atomic settlement, and so on and so forth, yeah? So, I would give a heads up to the audience, to the developers in the audience, if you have not already done that, Google after DLT pilot regime. There is a program you can apply under the regulatory sandbox and try to develop means to tokenize financial instruments, okay, via blockchain. That's a fantastic use case, okay? And those would be clear security tokens, yeah? And another remark, is a token, yes or no, a security? Very complicated to give an answer in Europe currently. But again, two recommendations, and I'm going to stop here. One, there is a survey done in 2019 by ESMA, again, European Securities Market Authority. They've asked all the securities regulators in Europe. They presented them with 5 or 6 concrete token cases and asked them which of those would be a security, and more specifically a tradable security or a financial instrument. Very interesting lecture, I highly recommend it, very educated. And last on the list, Q1 next year, so before end of March next year, ESMA is supposed to come out with clear guidelines on how to qualify whether a token is a security or not. So at that moment, things will be way more clear.
Yes, and if I may add, once this comes into place, then we will have an additional layer of complication on the tax side, because you will need to be very much aware on what are you holding, whether a crypto asset or a security, because the tax regime will change completely. Yeah.
Great.
It's not only bad news, Ioana.
Only good news.
It's clarity.
Clarity which brings
No, I know.
legitimacy.
But it's also obstacles, yeah? Because what you said about the reporting obligations, yeah, that will be a big burden on the crypto asset service providers, I think.
It's going to be on the crypto asset service providers, but at the same time, it's easier to be like that than on the individual investors, because that would be really a killer for the industry more than it is if you put it on the shoulders of the service providers.
Maybe one last question, maybe a yes or no question, although lawyers do not usually answer with yes or no to questions. I heard a rumor that MICA does not cover NFTs. Is that true, Andrei?
Yes and no. In the sense that, yes, prima facie answer is no, it does not cover NFTs. However, to the extent you'd have the NFTs fractionalized in what would be fungible and tradable fractionalized NFTs, that would be covered, okay? So that's the simple answer. Also, I would say, be very careful with NFTs because it really depends what rights do you embed in the NFT. And depending on those rights, and depending on the NFTs, yeah, you could go into the direction of the financial instruments. However, it's way less likely than it is for other type of tokens, simply because of the non-fungible nature, yeah?
Okay, going to the topic of stablecoins, let's speak stablecoins. It's a huge area in these days because, you know, they are those tokens that are being backed one by legal tender, so the volatile element is not present there. You can have discussions with banks and regulators about stablecoins. They are more receptive, and we tend to see them more and more as a use case that it is being applied in practice. Theoretically, we identified around 10 stablecoins backed by euro at the level of the European Union. Now, from a practical perspective, there is a discussion in case of each of such token whether there is actually a stable coin or another type of financial instrument, about, you know, the volumes that are being processed or how practical it is. For us, it's a very interesting discussion. We at MultiversX are in a position in which we have the necessary licenses from this perspective. We were curious if you have a point of view, Andrei, on, I mean, why do you think it's still not present, and why this opportunity, as we see it, huge from all points of view, like commercial, you know, this bridging the gap between financial financing and, let's say, the crypto space, which has the advantage of not having the volatile element, is not explored like 2 years ago, maybe?
Yeah. First of all, I would say, I don't know how many people know, because I was surprised to see that a lot of people from the crypto space did not seem to be aware about the fact that recently, a subsidiary of Societe Generale, yeah, one of the most important financial groups in Europe, named Forge, issued a Euro stablecoin based on Ethereum public blockchain. Yeah. Interesting choice, yeah, that they put it on a public blockchain. So again, I'm talking about the subsidiary of a large financial group. It's not a venture capital or something like that. That's an interesting signal to me. Yeah. Now, what's interesting is the way they did it. I read their white paper, and by the way, very interesting lecture. I recommend it to everybody. What's interesting to me is that they position it that this is not e-money, but rather placed it under some special French law. Okay. Now, and I'm going to come back to your question, but now the point is, when you say stable coins, you have to think, what are they stable versus what are they stable? Yeah. How do you maintain their stability? If they are backed by a currency, then under MICA, it will be very clear that they are e-money, okay? Which means the e-money legislation will also apply to them. And maybe that is one of the answers to your question, that before MICA, it was not entirely clear what is the nature of these stable coins, what would you qualify? I have to admit that first time I heard about them, I said, this is e-money. Yeah.
Truth being told, I mean, in our discussions with regulators, we try to explain about stablecoins like 1 year ago, 2 years ago, and then this year the discussions were like, oh, okay, so it's e-money, but it's not on card, it's on blockchain. Yeah. Okay, so you just apply the legal regime from e-money, like the same for the reserves and all that, and like, okay, that's easy.
and it makes all the sense that they said that, because there's a very clear principle in the e-money directive saying that it is technology neutral. So, you know, whether you use blockchain as a technology for e-money or other technology, that should not change much as long as it's a sound technology. Yeah. So maybe an answer to your question is that people were a bit hesitant in terms of issuing a stablecoin because they were not clear about under what legislation it falls. Yeah, I think MICA already gives clarity by basically saying only credit institutions and e-money institutions will be allowed to issue, stablecoins. Okay, and again, I'm talking about stablecoins, not about asset reference coins. Yeah.
Raluca, what is, from a tax perspective, maybe the relevance here when we change from other type of digital assets into stable coins, from stable coins to fiat? Does the topic stablecoin raises any tax challenge? Is there any discussion from this perspective?
It does raise, and I think we get this question quite a lot when we speak to people in this space. Truth is that right now my interpretation is that we would treat stablecoin same as any other crypto asset, and the transfer, as I explained before, as long as it is kept in that space, should not trigger an immediate tax liability. But hearing Andrei here saying that if we would be get to that space where stablecoins are seen as e-money and then are to be issued by credit institutions, then I think we are speaking about a different regime. I mean, we will transition. It's like taking it out to fiat. Yeah, you are in a regulated space, and that would require, a taxable moment.
So again, good news and bad news. Yeah, the good news is that
Again,
the regulation will bring adoption for sure. Yeah, I personally have no doubt about that. Yeah, but it also will impact potentially the tax treatment. Yeah. Because stablecoins, are, I believe, largely used as a way of, turning your crypto into a stable asset without exiting in fiat. Yeah, which, as long as it's not taxable, that's great. But when this change, it changed.
maybe a last question, Andrei, on a bit about MICA and try to rehabilitate it even more. So now projects which have this CASP, DASP, VASP type of license, depending on the country, they are either digital assets, virtual assets, crypto assets type of licenses. They need to take regulatory steps in all the countries where they are present, more or less, because this type of services that are being offered, they can be accessed from anywhere. Various jurisdictions, they have various definitions on what is marketing, what is reverse solicitation. So it's very complicated for a project, for a business like we are, to be regulatory compliant in each jurisdiction where a certain service can be accessed. And to make things even more complicated now that we also have the Brexit, we have UK, which adds complexity to the matter. Would MICA, for sure it will change from perspective of the fact that it will make a license obtained in a state of the European Union usable in the other states. Now, going back a bit to UK, how are things from this perspective? Is a business regulated in UK, can it serve European Union clients, and maybe vice versa? Our licenses that we have in various countries from the European Union, can we use them in UK?
Okay, so what MICA does is what the European legislation did for financial services in general. It introduces the principle of passporting, which means exactly what you said. Once I licensed in one EU member state, I'm able to passport that with a quite simple procedure in any other state. When it comes to non-EU member states like UK, several things to be said. No, passporting from Europe to UK or from UK to Europe doesn't work. Okay. However, to my knowledge, there are similarities, not identity, but there are similarities in terms of how UK is in process of regulating VASPs, for example, and how MICA is doing, which means we may reach a level of what is called equivalence of regulation, okay? And that could make it easier for a UK license to operate in Europe, but would still be subject to an authorization process. It will not be automatic passporting, okay? So that's something to be kept in mind. Another point to mention here is transitioning to MICA, yeah? As of now, we have several types of crypto asset service providers. Some of them are operating under general principles of law, like what's happening in Romania. Okay, we don't have some law to prohibit to be a crypto exchange. Okay, we do have the anti-money laundering law, Law 129, which says that there will be secondary legislation that will establish under which terms should be licensed for crypto, fiat crypto, and custodial wallets. Yeah, that secondary legislation is missing. Okay, and we have other countries which have legislation saying how do you get a license there, strictly under the AML rules. And then we have other countries in Europe which have a much more developed legislation, and actually they're enhancing it to look like MICA. Yeah, those are the best countries in my view. Okay. Because for the entities licensed there, it will be way easier to get the MICA license. They will be much more prepared. A heads up to the operators which operate in jurisdictions like Romania, yeah, Romania or others, where you don't have a special legislation, not even under the AML rules, because it's debatable whether, what will next Christmas bring to them. Yeah, as I said, next Christmas puts MICA into place, and it says that the home member states can still allow another 18 months for transitioning to a license to the virtual asset service providers which are already operating in accordance with the local law. For the countries where they are operating under special legislation, so they have some sort of license, even under AML, they, in my view, will be able to benefit of the extra 18 months. For the countries where you don't have that special license, it's a question mark.
Another one. We hope what you've heard today on the stage was useful. It was just a flavor. 30 minutes is not a lot. But as a conclusion to our discussion, the regulation that is coming will help from many perspectives, will validate businesses in this space. We already see the impact in the sense that discussions with regulators and banks are more relaxed now that there is a legal framework. So, yeah, all good from this perspective. Thank you, Andrei. Thank you, Raluca.
Thank
I would
you.
say that they're not only relaxed, I think they also don't have enough institutional capacity to handle it.
Thank you.
Thank you.